I'd like to call the docket to order. March the 7th, 2019. Southern Room A, 1:30 start. This hearing is being convened as a continued hearing with respect to multiple applications pertaining to 99 East Avenue, Hamilton, Unit 2. Those applications are SOL 84218-17, SOT 77620-16, SOT 80393-17, SOT 91682-18, SOT 99829-18. If the parties would identify themselves at this table.
Marie Ball.
Paul Peter Bosch, but I go by my middle name Peter. So if you hear someone refer to Paul or Peter, they're both me.
And you are the?
We're the tenants.
Any witnesses today?
No, they don't seem to have showed.
At this table?
Yes, Greenway, initial J.
Ms. Greenway.
Licensed paralegal, and I'm acting for the landlord, John Serino.
And sir, could you state your name?
John Serino.
Any witnesses? Ma'am, any witnesses?
One.
All right.
One besides.
Understood. Thank you so much. Maybe what I'll do is exclude the witness at this time. Where is that person? All right, so I'm going to ask you to remain outside until you're called. All right. Now, parties, I won't go through my general preamble again. You've been before me in the context of a co-panel on the history of these matters. I want you to understand, well, first of all, I'm Sean Henry, of course, member of the board. The prior attendances on this matter were brought on by way of co-panel involving member DeLeon Culp and myself. She has since been removed from these matters. It will be my intention, should the hearings proceed, to consider the matters afresh. We didn't get far into them in any event, but that'll be my intention. I'm going to, now, that being said, I don't know if you want to hear the preambles. You've probably experienced both of them before, but I'll give you that opportunity. Mr. Duty Counsel, do you want to give Dave? This is a Duty Counsel. Okay. You've may have engaged with him previously. He's here, of course, to give you legal advice in advance of the hearing, should you wish. And Ms. Jackson is the mediator. And I think I've previously explained the nature of the mediation service, correct?
Multiple times, sir.
Well, we've been here multiple times. That wasn't a facetious comment, was it?
No, sir, it
Oh,
wasn't.
good. All right. I'm going to recess very briefly. Yes.
Mr. Bosch has signed up to see me.
Oh, is that right?
That's correct, sir.
All right, then. I'll let that happen, then. We'll recess for that purpose. Thank you.
I'll quickly address them while you're gone. It's to my role, just in case they don't know.
Very good, sir. Thank you so much.
Thank you.
I don't know, do you want to do the same, Ms. Jackson? Or they've been exposed to the media preamble. Maybe they want to be introduced to you, but
Well, maybe if you want to speak to them about mediation, I can give them advice and see if that's an option that they can consider.
Chairman Henry, I
Yes.
just wanted to make you aware that I'm new on this case.
Yes, ma'am.
Vidi Yakini
Yes.
has become ill.
I understood that. I heard that through the grapevine.
Yes, so I'll be taking over.
I quite understand, ma'am. When you speak with her, please extend to her, on behalf of the board, our best wishes for her good health and recovery.
Thank you.
Thank you so much. Recess. Got to get back on record. Okay, Mr. Bosch, you've spoken with Duty Counsel?
I have.
And Ms. Ball, are you content to proceed?
Yes, I am.
Have you spoken with Duty Counsel?
I've been informed what they discussed, yes.
Did you want to speak before we proceed with Duty Counsel or no?
No.
All right. All right, now the witness is outside, right now?
Yes.
Mr. Henry,
Yes.
I have some preliminary issues. 5 of them, actually.
Just hold on a second.
Sure.
All right. Now, before you get to those, in terms of the format, I indicated earlier that my intention will be conduct the hearing afresh. I'll tell you why that is. Okay. The panel has been now differently constituted. Member Leon Culp would have taken notes different than mine and would have focused on articles of evidence that may have perhaps with a different lens than I did. I think it incumbent on me to give the parties full shrift of my unique focus on everything, distinct from my co-panel experience, so that everyone has confidence that I have the benefit of everything that comes into evidence. Is that understood?
Yes.
I can't hear you.
Yes.
Okay, when I'm asking questions, and we've been perhaps through this, in that these hearings are being recorded in audio fashion, the only way that your engagement can be recorded is if you vocalize your communication. Does that make any sense?
It does, Mr. Chairman, but I wasn't aware to whom you were speaking.
Well, I'm speaking to all of you.
Okay.
Because are you not involved in this hearing?
Yes.
Okay, so when I'm asking if that's understood, I'd like you to consider that I'm also including you because you're participating in this experience. Does that make sense?
Yes.
All right. All right, so to the preliminary issues. Now, before we even proceed to that, My intention will be, there are several applications. How many? 6, 7? I think we started off with a few, and then over the course of time, several more have been filed by the parties. That's absolutely fine. My intention will be, subject to any winsome submission to the contrary, to start with the most historic application and deal with these things chronologically. Now, Ms. Bosch, sorry, your preliminary issues?
Well, you just covered one of them. I would like to present the case chronologically. I've raised that issue before, and specifically on the hearing in last September 25th. And again, during the...
Excuse me? I've already made the ruling, but that was my intention. Are you attempting to kind of buttress my decision?
No.
Okay. Are you not content with that thought process?
Okay. I'm not sure how to phrase this without sounding disrespectful, sir. and that's not
Just
my
talk as you talk.
Okay. Marie and I have both noticed a propensity on your part to push for mediation. There was a 10-minute hard sell on that on September 25th of last year.
Okay.
And the first part of the hearings in another 17 or 18 minutes, during which time you told us at least 15 times that you weren't pressuring us for mediation.
Okay.
Sir, I mean no disrespect by this, but if you're sitting 6 feet above eye level and either figuratively or literally holding a gavel, telling me something repeatedly that you're not pressuring me,
Okay.
it does feel like pressure.
I see your point. Okay, I'm glad you shared that on the record.
Now-
Go on. Go on.
It is our position that our landlord has misused the mediation process to create delays and to introduce misinformation to
Okay.
us by continually hard selling mediation.
Okay.
That has, and again, I mean no disrespect, sir, but that has created what appears to me a bias in favor of a certain process.
Okay.
And I do not believe that mediation as practiced in this office has any possibility of producing a just result.
I hear you.
Okay.
Okay.
I was quite specific in the telephone hearing that what we seek is justice.
Okay.
Okay. So we would appreciate if you would not pressure us for mediation going forward, because it's pointless. Mr. Serino, even if he does come to an agreement in mediation, ignores it. And a particularly vivid example of that is the last interim order you issued. I plan to show you the videos of his entry. Now, there is also a statement that you made during the September 25th, 2017 hearing that the delays in the case were due to the way in which we had originally presented our case, which is to say chronologically. Again, Mr. Chairman, there is no other way to present this.
Okay.
It's not possible. However, when I informed you it would be 3 to 5 days of hearing time, which it is, sir, you responded with a veiled threat to assess me costs.
Oh, let me interrupt you there. First of all, there are no threats. Here, I'm going to tell you what this, because you obviously have a misunderstanding of that process. Bear with me briefly.
Sure.
The board's rules of procedure afford the board discretion to assess costs for circumstances related to unreasonable conduct.
Okay.
Let me finish. We're not there yet. But I have an obligation to the administration of justice in relation to fulfilling the board's primary mandate. Let me share with you what that is statutorily. It is to conduct hearings in an expeditious fashion in a manner that preserves a party's right to participate in the hearing. It involves juggling competing interests. In fact, this tribunal was structured for the purpose of ensuring efficient disposition of applications. Here's what I'm going to do in every case. Your case is no exception. I will let the parties know the parameters of my analysis and the principles that I apply with respect to the case management dynamic, which is my obligation. I haven't assessed costs, but the specter of costs will always be live when I determine that unreasonable conduct has led to undue delay in the process. I need you to understand that.
Okay.
That is part of my jurisdiction. Parties don't have to advance claims before this organization. That's their election. But when they do, they submit themselves to our lawful jurisdiction. Do you understand that?
I do.
Please go on.
However, your original comment that the delays in the case were due to the way that we originally presented it. Again, sir, no disrespect, but it appears to me that you have already made up your mind on that.
On
your
what?
Statement.
On what exactly?
That the delays were due to the way in which we originally tried to present our case.
Give me a moment. I'm just taking some notes. That's right. I'm just taking some notes. Do you mind?
Okay.
All right. I have to write. Is that okay?
Give them a few minutes.
I can't hear you.
Yes, sorry.
Okay, so I've written down my comment that you're responsible for the delay might result in costs arising. Sorry, you said something about bias now? Go on. Suggest that I am biased in the disposition of your applications?
I don't know that it's bias. It suggests to me that you've decided a key part of our case ahead of time.
Which is what now?
Well, part of our allegations are coercion.
Okay.
And what we're alleging is that Mr. Serino's overall pattern of conduct
Okay.
is also coercive as well as individual acts.
What part have I pre-decided again?
Well, part of that pattern of conduct is his delay in the hearings to give himself time to harass us.
Okay.
I believe he is responsible for that, he and his former representative. And you appear to have already decided that it was our problem, that it was the way that we originally presented our case.
Okay.
Now, that means we have an uphill battle to convince you otherwise.
It doesn't mean any such thing. I think you've misconstrued everything. May I engage briefly? Because I think you're way off course.
Absolutely.
I haven't decided a thing. Here's how this works, though. Parties inevitably have a limited amount of time before me. Whatever that limit is, it's not an infinite amount of time. My goal in engaging this process is to have everyone focus on issues relevant to my jurisdiction. I do this every day.
Okay.
So I might have a better understanding of the parties at large with respect to the framework of analysis I have to apply the disposition of their cases. In fact, one of my jobs is to engage process for the purpose of keeping everyone on a track. I haven't made any rulings with respect to costs. But I mean, I'm not trying to defend my decision. I just wanted to I wanted to intervene for the purpose of kind of informing your understanding of what I am doing here. But please go on.
Okay. Well, I'm not saying you've made any rulings, but I'm saying that your words give, to me at least, the appearance that you've already made a decision.
On what issue now?
On the key point of our case, in that the delays are due to Mr. Serino's conduct, not ours.
Okay, I'm going to say this. The delays in the disposition, may I offer this, just for an orientation? Whatever delays may or may not arise in the context of the disposition of the application through the hearing process are distinct from my analysis on the merits of the application. Those are two different circumstances.
Okay.
Do you understand that? The issues pertaining to possible delay in the process can only delay process and possibly result in the specter of costs. But they don't impact my analysis on the merits of the application. Those are two different avenues of consideration. Does that make any sense to you at all?
Well, it does, but now our case is partially based on showing you that the delays were due to Mr. Serino.
What delays? The delays in the hearing process?
Yes.
We're way beyond that. I'm told that's not even in my head at all. We're not even close to being there. Because this matter we couldn't dispose of it. Look, here's how this works. When I am of the view that we are getting logjam in terms of a presentation, I will identify that to the parties. Because one of my obligations is to get you through the process in a reasonably expeditious fashion. I recognize that there is an inherent opportunity cost associated with parties' multiple attendance before the board. One of my goals is to engineer a process that can get them from A to B in a fairly efficient fashion. But I'm not trying to sound like an apologist for my approach. I'm not even entirely familiar with everything you're talking about. But that being said, I just need to understand. So the landlord is responsible for the delay in the hearing process. You're not. I get you. Go on. What else? Where does this lead? What are you suggesting?
Well, that you had decided one of the key elements of our case.
Which is what? What did I decide already?
That the delay was due to us rather than the landlords.
Okay. We haven't even gotten through the landlord's presentation yet. He may or may not contribute to any delay of process. I haven't made any rulings. You've been the beneficiary of my interim orders, right?
That's one of the next
Okay,
preliminary issues.
I'm asking you a question. Why don't you be responsive to my questions, and then we'll progress through this reasonably well. Is that reasonable? You've gotten my rulings.
I have.
Have I made any rulings with respect to holding you to account for a delay?
No, but, okay, you're correct.
No. I'm just trying to, look, when you're making arguments, you've got to lodge them in something. I'm just trying to understand where the nugget of this lies. Your concern is that what? I'm not in a position to judge your case fairly?
Yes, I believe so.
Okay. I just want to put words to your thinking.
What has gone before has colored what you will see coming.
Okay, I'm sorry, I am colored in my analysis because I have attributed some delay in process to you. Is that the nugget of it?
There is the appearance of that.
Okay, I get you. I'm just trying to understand. Okay.
There is the appearance that, to my eyes anyway.
I know.
If I'm wrong,
all I want to hear is your truth. Listen to me. I need to hear your truth. I just need to understand it.
Okay.
In your mind, it's crystal clear, but your words need to convey meaning to me. Does that make any sense?
Yes.
So I'm just summarizing what I think you're saying to make sure I'm tracking. Is that okay with you?
Okay.
I hope you're not considering that problematic. I want to make sure I'm not treading on your toes.
No.
All right. I am colored in my analysis because I determined that the tenants, I orally ruled, right? That the tenants were delaying process in the hearing. Is that correct? Is that a proper framing? You tell me how to put it.
Not just in that hearing, though, but overall.
Well, this is the hearing. The hearing is a continuous event.
All right.
You and I don't interact outside of the hearing process.
No. Well,
So, what? Do we?
well, very briefly.
How?
But, you came into the room down there and asked the woman at the counter if there was a commissioner around, and I saw one standing outside the door, so I said, "There's one over there, sir."
Okay.
And you walked out and said, "Thanks."
Does that represent a problematic interaction from your perspective?
No, absolutely not.
All right. So I'm colored in my analysis because I early ruled previously that the tenants were delaying process. Okay. They're delaying the hearing. Okay. All right. All right. I'm hearing you. And what are you asking me to do?
Recuse yourself, sir.
Okay. All right. And just so I understand, because you feel that I've decided something that impacts the substance of your case, is that part of it?
Yes.
What is that exactly?
That the delay in the hearing was due to the way in which we originally presented our case.
But how does that so recusal, let me just frame out what I think you're saying. Okay. A recusal under the circumstances that you're identifying typically would arise through what we characterize as a reasonable apprehension of bias. I'm assuming that's kind of what you're taking. You're not using that terminology, but I'm thinking that's where you're going. So I'm just trying to make sure that that's what you're talking about.
Sounds like a good description, yes.
All right. Such that a kind of a reasonable and neutral person looking at the matter fairly through an uncolored lens would assess the likelihood that I would not be applying a kind of a fairness to my analysis of the facts, right? Is that kind of what you're saying? Okay.
Yes.
I'm just trying to get it. I don't need you to use my terminology, but I still make sure that conceptually we're on the same page into what you're talking about. Okay. Gotcha.
Now, I'm not saying that it does exist. I'm saying the appearance.
I know what the threshold is. Actually, I get it. And I don't believe you. I'd rather you tell me your truth, because I can't be offended. Don't worry. But I hear this kind of stuff from time to time. This is my role. So don't think in any sense that I'm somehow inflamed by what you're telling me. I'm just trying to understand what you're telling me. Okay. So this reasonable apprehension of bias arises because I made a ruling I told you that you were slowing down process, correct?
Correct.
Okay. So help me understand where the bias arises in that. How does my ability to assess the case, how is that impacted by that?
Again, I'm not sure bias is the correct term, sir. It is you appear to have prejudged that point.
Well,
is that bias?
If it is. Okay, if I assess that you were not being efficient in process, I may very well have. I don't specifically recall, to be honest with you. You can see how nominal a consideration that has been for me and that none of my orders reflect anything pertaining to that.
Okay.
But, so, understand something. I just need you to know something. This case was last heard many, many months ago.
Yes.
In my analysis, having reviewed the matter prior to coming back on it, nothing turns on what you're arguing about. In my own assessment of the case, but there's something to you that impacts my ability to be neutral in evaluating the case. And because obviously none of the orders even reflect the consideration of this is not even on my mind. But I need for you to understand, I need for you to help me understand how my ability to neutrally evaluate the evidence is negatively impacted by me telling you that you were slowing up the words. Help me to understand that.
Okay, I think you have already evaluated what evidence you had and come to the conclusion that the delay was due to the way that we originally tried to present our case. You said so in the hearing, sir.
But, okay, I'm really confused. Actually, I'm sorry to say that. I just don't understand the linkage you're trying to establish. I'm not trying to be ignorant, but I don't get it. I'm going to give Ms. Greenway a chance to cross-examine you shortly, and I'll hear from her in response. But I first need to apprehend what on earth it is you're telling me.
It's not just the evidence you've already
Okay.
heard. It's evidence we will also be presenting that could be colored by that.
All right.
Yeah, that's a good way of putting it.
All right.
That point is going to be important
Okay.
on the coercion aspect of our case as to who's responsible for the delays.
Because the delays have also offered
The delay, when you say delays, you mean delays in the hearing process or delays
Yes.
in... Let me finish my sentence, please. Because I need for you to understand what I'm asking. Is that reasonable?
Yes, sorry.
Yes.
Okay. Is it delays in the hearing process or is it delays in whatever issues arise in the application?
Delays in the hearing
Okay.
process.
And you feel... Okay. So my having ruled around me having around delay in hearing colors my ability to fairly assess the evidence. I guess that I want to make sure I'm capturing it correct because I don't want you to, on reflection, say Mr. Henry didn't even capture my point. So let me paraphrase the wording I intend to set out in my notes so I capture your thought. Is that fair?
Sure.
Yes.
Okay. My having spoken around the delay in the hearing in the past colors my ability to fairly assess the evidence in this case. Any more on that? Or
Present and future.
I get it. I get all the evidence. I get it. But anything else to help me understand the linkage, or is that everything?
Well, that and I guess the mediation is a dead issue.
Okay.
Yeah.
Listen, I didn't mention mediation today. The mediator has an obligation to attend and make her own preamble. I said nothing about it. So please don't mention that again. Okay? The reason that I'll let you all know in on something. I guess it's all a threshold in each party's mind as to, or an interpretation as to what's going on here. Okay? I'll be quite candid. I don't care whether parties mediate or not. At the end of the day, that is a private assessment that parties have to be able to make. Now, it's possible that being a lay party and being there, the words that I may have chosen, I don't even remember them, may have impacted you in a manner that might have seemed depressive. I don't know. But I'm just interpreting the possibility from how you seem to have reacted to my prior statements.
They did, sir.
Okay, and I'm glad you let me know that. But I want everyone to know, it doesn't matter to me what any of you do. I get paid whether or not you all mediate. I'm just letting you know that. I am actually at arm's length from the parties. That empowerment and election is yours. But I will say something. When I amplify in the mediator's preamble, it is only for one reason. I may share with you what that is. At the end of the day, in every hearing process, someone walks away disgruntled. Someone does. I can't make both parties happy. I've seen this in every single case I presided on since I started working here. And so I really like to emphasize to parties at the end of the day that they have an option so that nobody risks feeling dispossessed of their preference at the end, because I try to empower. That's the only reason I do it. But again, you don't have to do it. But I'm glad you shared with me your impression around my engagement there. That's helpful for me in terms of my own engagement in the work. Okay, so I get you. No more mention of mediation. I got you. I didn't today, and I won't hear it again. You won't hear it again, fine. Now, is everything on your... I'll frame it as apprehension of bias, because I'm using our general terminology to characterize what I think you're saying. I am unable to fairly dispose of the case because of some outlook that I have, right? Is that a fair characterization?
Yes.
Okay, gotcha. Is that everything on that matter?
Yes.
Thank you for that. Any questions, Ms. Greenway?
No, I have none, actually.
Okay. Do you have any submissions?
From what I understand,
It's not forced. Can I say something?
I don't know, it's up to Ms. Greenway.
Okay, go ahead. You can say that.
Number one, mediation is not forced.
I'm not even worried about mediation.
Okay, it's just offered.
I think what I'm hearing from the tenants is that they felt unfortunately compelled in how I engaged them. I didn't mean to do that, but I'm just trying to give you some confidence. Well, I didn't say it today, I'm not saying it again. If that, does that satisfy you, or is there something else in relation to your concern pertaining that you wanted me to address? Or on the mediation? Because the landlord's going to make submissions on the mediation. I don't even know if that's relevant, but I think you were just trying to communicate to me how you felt, your subjective feeling, and I wanted to let you know I acknowledge that, and then I won't make mention of it again. But was there some outcome you saw in relation to that?
As far as mediation goes, no.
Okay, so that was you were just sharing your perception. I appreciate it. So don't even talk to me, landlord, about mediation. They were just trying to share their thoughts. What I'm really more concerned about is this bias claim. Do you ever? I'm obligated to give you a chance to respond to any submission or no?
No, we do not.
No submission?
No.
Okay. All right. Okay, I'm going to make a ruling on it then. Okay. I don't see it. And I recognize that the argument is the specter of bias, not the reality of it, okay? So I'm applying a very low bar to this assessment, okay? I don't see, and this is why I've been asking you the linkage, because I've been trying to drill deeper to see if there's what nugget you can present to make the attachment between the concept and the evidence. I don't see it yet. That being said, bear with me, I'm just making some notes. Who's to say, as the hearing unfolds, you may garner information that will allow you to advance this claim of fashion. I don't know, but that opportunity for you to make the request is always live. Does that make sense?
Yes.
We've barely scratched the surface on any of this stuff. So, but I will always be open. There's my biggest concern are these issues, because it's the bias specter that taints the legitimacy of the process. So I am most concerned with respect to that. I'm always be alive and open to any concerns you might have. So as we go ahead, these hearings are going to take us multiple attendances. There's no issue around that. If you have any concerns, raise them around that. I need to hear on that stuff. Does that make sense?
It does, sir.
In the moment, though, what you've told me doesn't meet the low threshold test. I don't see it, at least in my assessment. But if something comes up later you want to tell me about, which I'm going to think you're biased because of this, got to tell me that, and I'll consider that. Make sense?
It does.
And I'll consider that, I'll look at this in its totality, including what you told me today. But right now, you're not quite there yet. All right. So that's the first issue. What's the next preliminary issue?
The next one is a late disclosure on this application.
Okay.
We received this envelope under our door yesterday at 4 o'clock.
Okay, bear with me for 1 second. I'm just going to refresh my recollection as to any previous disclosure requirements, okay? Just hold on a second.
If I may, that will not be used anyway.
Oh.
That
Okay.
disclosure will not be used anyway.
All right. You want to answer that?
My apologies.
Not a problem. Okay. Well, sir, Ms. Green was telling me, that package that you presented, that you showed up to me, they won't be looking to rely on it. So if that's the case, I imagine there's no request you need to make here. Is that a fair understanding, or is there something else you want to tell me on that?
Well, there's information in there that's a game changer. And
Well, if they don't use it, then it won't change again.
The information is that Mr. Pollington is illiterate. So that information I pretty much have to use. A lot of his statements have been made in writing.
Well, nothing stops you.
Okay.
Let me tell you how this all works. Nothing stops you from presenting. Well, actually, let me frame this more carefully. Okay, let me get back to the disclosure regime set out in the prior order. Okay, if there was one there. I'm assuming there was one. Way back at the beginning, perhaps. Yes, here we go. All right. And member Leon Culp's July 11, 2018. Okay, so I did institute a disclosure regime. Now, let's think this through. I'm making some notes. So, late disclosure by the landlord. I'm just taking some notes here. By a landlord. Yesterday you received that package?
Yesterday at 4 p.m., sir.
All right.
This is the latest in a long line of
Okay.
disclosures.
Okay, you know what? This is not how this works. Actually, you're not helping me. I'm just asking you a question. I have to take notes in relation to it. And when you speak extemporaneously, beyond the scope of what I need to consider, it doesn't help.
Okay.
It might give you personal satisfaction. This is the latest in the series, but this is not the way you do this work before me, because I'll get confused, because you're talking to me and I'm writing. But all I'm doing right now is addressing the timeline of the disclosure. You don't need to amplify it by going into a histrionic soliloquy around this is the latest in the series. That won't help because I'll get confused.
May we say, we're sorry.
I'm not upset, but I'm just trying to. You don't know what I have to deal with, so I'm just trying to help educate you with this process. I have to focus on things, and when you speak extemporaneously on matters not relevant to my consideration, you're just confusing me. Does that make any sense? I can't hear you.
Yes,
Okay, I hope you don't think I'm being biased there, but I'm just trying to let you know my process. Is that fair?
that's fair, Mr. Chairman, but
There's
Okay.
a level of frustration.
I understand that, but you don't. Look, I'll let you tell me whatever it is you want to tell me, relevant to any of this, because I won't know if it's relevant until I hear it. But I'm trying to take notes in a response to a question I put to you. When you start talking about other things not directed to what I'm writing on, my focus is divided. Does that make any sense?
Yes.
I'm not trying to be difficult, but I'm letting you know how I can best receive information to give you what you're telling me full shrift. Any concerns there? If there are, let me know.
no.
Okay.
Just go slower.
Okay. Landlord disclosed package yesterday. Okay. All right. Now, landlord says won't rely on it. Gotcha. But your concern is that there's information in that package that you want to rely on. Is that a fair surmisal?
Yes, it is.
Okay. Alrighty. Well, okay, so I'm going to take some guidance from the disclosure regime that was established on July the 11th. Otherwise, we'll never make our way through this case. Okay? I'm holding parties to the timelines there. Now, had the landlord chosen to rely on that document, or those documents, for sure you'd be in a position to use them to your benefit. Does that make sense? Because they'd be introduced into evidence by the landlord. I have no problem with you introducing them to evidence in broad strokes, except for the fact that you'd be in defiance of the disclosure regime. Does that make sense?
Yes.
And I need to keep this thing moving forward. Does everyone understand that? So I'm not going to let either party rely on documents that weren't disclosed in accordance with my regime.
Yes.
If I didn't do that, I'd have to adjourn this so it would just create another challenge. I want to give you all a conclusion at some point. Is that fair?
Yes.
Yes.
You let me know if you think I'm being biased. I just want you to know I have an open mind with respect to that. If you think something is offside, you will let me know. You too, ma'am. Is that correct?
Yes.
Sir?
Yes.
All right. Let's keep going. All right.
My only request on that subject is
Yes.
if you look, there has been a history of last-minute disclosures by the other party.
I hear you.
We'd like that stopped.
Well, what I will intend to do, as it relates to applications that have not yet been considered, is actually what did I do? There was an interim order where I think I set out. Mr. Commissioner, can you go look in my inbox just at the door?
Yeah.
I think there was an order directed to all these elements, or is this it here? Hang on. No, I apologize. I got it right here. Okay, I actually provided a disclosure regime with respect to 4 of the applications. I think since then new ones have been filed, right? Okay. Okay, so what I will intend to do, sugar. Let's do it this way. The regime governs 4.
Excuse me, Mr.
Yes.
Chairman. Which document are you reading from?
I'm reading from my July 11th order.
Okay.
That set out the disclosure requirements.
July 11th of last year.
Yeah.
I
Right?
have it.
Now that order, the disclosure feature governs those 3 orders. I'm not going to let anyone, absent a truly extraordinary winsome submission, violate that order as relates to those 4 applications. Does that make sense?
Yes.
We have other applications that are not subject to a disclosure regime. I don't intend to address those right now. I want to see what we can get through on one application at a time. Does that make any sense? But to the extent that either party violates the disclosure regime in relation to these 4 applications, we're going to have a problem.
Yes.
Make sense? All right. All right. Now, I'll say this to you. I'm not giving you advice. I think you have a couple more applications that you filed that aren't subject to this order. Not subject to this order. Am I right? A few more came in.
Yeah, one in December.
Right. I don't know which one that is, but if there's information that's come to your awareness that is germane to any of the issues in the applications that have not been before me yet, you're not subject to a disclosure requirement. You could rely on them. You could still use them. Do you understand that?
Okay.
Does that make sense to you, ma'am?
Yes.
For those orders, for those applications. Okay. All right, so I'm going to, at this stage, deny your opportunity to reuse those documents because you didn't disclose them to your landlord. When I say disclose, the landlord wouldn't have known of your interest in relying on them except for today or before today. All right? All right. So the next preliminary issue.
Okay. I have a question about
Sure.
what you just said. Mr.
Sure,
Chairman.
absolutely.
Does that mean that these documents can be used in the next hearing?
Well, no. Good question. The July 11th order governs 4 applications. Is that right? Okay. You might have, there's so many of these things here. You may have a live application that is not subject to this order. Is that right? I don't know if you do, but several more have been filed since.
Yes.
Okay. Those applications have not yet been subjected to a disclosure regime, meaning you can use whatever you want in relation to those applications not governed by this order. Does that make any sense? If they are germane to it, is what I'm trying to say. In other words, you may still be able to introduce those in matters that have not yet come before me. Does that make any sense at all?
Yes.
All right. Does that conclude that issue? I made a ruling on it, but anything else on it? No. All right. The next issue?
Okay, the third preliminary issue is who are our landlords?
Okay.
Yeah.
We've been told Agostino both is and is not a landlord. He has acted alone as the landlord in a previous tribunal matter. For
Agostino?
argument. Agostino.
Who's that?
Mr. Serino's brother, John's brother.
He's in the hallway.
He's
In
what?
the hallway,
He's in
he's
the
the
hallway.
witness.
He's the witness.
Well, okay, so let's just stop for a second, just to get our bearings. Now, the previous interim orders didn't direct themselves to issues of status. We just agreement just captured what was said on the application. But of course, we only had John Serino as the landlord historically. But now you have a question as to who the actual landlord is. Is that right?
That's correct.
Okay.
Yeah.
All right. Is it a question or is it something? Do you have a position other than John Serino, or are you simply asking for clarification?
We're asking for clarification, but there is some evidence to suggest that Agostino is a landlord. And we've been told that he's not, but we've also been told that he is. So clarification, and depending on what that clarification is, we may argue.
Alrighty. Well, it falls in your court on this, man, Ms. Greenway.
Well,
Who's the landlord?
John.
I'm the
John
landlord.
Serino is
I'm the owner. My brother is part owner with me. Part owner with me, but I'm on the deed. We both own the property.
Okay. All right. So you're a you're co-owner.
I am the owner on paper. My brother's a silent partner.
What does that mean?
That means that we share both responsibilities with the house.
Okay, Ms. Greenway, I am really confused. We both know that the definition of landlord is not exhaustive and it's fairly broad.
It's John.
I don't know what on earth he's telling me.
I am the owner.
John Serino is the
Solely?
landlord.
Yes.
Yes. He has people that work for him, which Agostino is one, and Richard Paulington is the other.
So what's his name? Augustino?
Augustino.
How do I spell that?
A-G-O-S-T
Yes. O-S, right?
I-N-O.
Okay, it's the same last name? It's
Yes,
Okay.
yes.
All right, there. Okay. And that's the landlord's brother, right?
That's the landlord's brother, and then there's...
Is not a landlord. Is that what
he's
you're
not entitled the landlord.
Is what?
He's not the landlord.
Is not a landlord. Is not a landlord.
No, he
Okay.
works for the landlord.
All right.
Can I interrupt? He is a landlord at other properties.
But not this one.
Not this one, but he is a landlord.
This is what I'm trying to say.
Okay.
It doesn't. Okay. This is the problem. Things that don't bear on my jurisdiction being introduced. You see what? Now you see from the other end, right? The fact that he may be a landlord elsewhere, they may not be germane to my assessment here.
Okay.
I would dress him down, but I think Ms. Greenway sees the problem. I'm just trying to introduce the parties how we can make the hearing effective by engaging only on relevant and probative issues. Does that make sense to anybody? I can't hear anybody on
Yes.
this.
Yes.
You see how it works the other way.
Yes.
And I'm not happy with that either. All right. Okay, so is that everything on...
And Richard Paulington is also an employee in case that comes up.
Well, I think the tenants were only concerned, I'm assuming, as to whether Agostino was a co-landlord. Is that right, sir? Or what's your position? You don't know. You're just asking for clarification, right?
Yes.
Okay,
Yeah.
so let's just focus on Agostino. He's the only one that they seem to have a concern about.
Okay.
Is that everything with respect to the identity of the landlord?
Yes.
Okay. Do you have any questions of the landlord with respect to the identity of the landlord?
Okay, well, I'd like to introduce some evidence in support of the motion.
What?
actually support your question, but
In support of what?
something I'd like to have explained. It's was obtained through a Freedom of Information request, and it's a file, copy of file number SOL 19372-11.
Oh, is it an order?
Yes.
Oh,
yes,
okay.
it
Is it named someone up as the landlord of this unit other than Mr. Serena?
Yeah, name's Augustino.
For this unit?
Correct. As far as I can tell.
I'll take a look. Do you have a copy from the screenway?
Yes, I do.
All right. Thank you. Now, this kind of runs a little afoul of the disclosure framing, but because it's not a preliminary issue, I'm going to turn a blind eye to it, at least for the moment.
Well, this was disclosed
Or was it part of your...
early 2017, I think.
In relation to the application?
Yes.
All right. I didn't know that. All right. So bear with me.
So this one does actually fit the disclosure regime.
I'm glad to hear that. Okay. So let's see here. SOL 19372-11. I see. Okay. Augustino is the sole landlord.
Yeah.
Bear with me. And that would have been in an order issued by Member Beckett, February the 7th, 2017. All right.
Sorry?
Yeah, February the 7th, sorry, February 7th, 2012. My apologies. All right. Well, I mean, this might bear some explaining, Ms. Greenway. Any response to this?
Just a moment, actually.
Actually, you know what?
No, that was the wrong order.
You know what?
sir.
You gave me a compendium of two orders combined, 4 portions of them, right? I see that now. One by Vice Chair Member Van Gelt, as she was then, and another from Member Becker. I'll give them to me in the same document, but they're different, right?
Yeah, that's correct.
So which one do you want to take back?
The second one, I want you to keep
They're both
SOL
together?
19372-11.
Okay, I'll give this back to you.
Sorry about that.
No. All right. Okay, here's the other one. There's a portion of the other. Actually, you know, all I have are reasons for this one, though. I don't have the order itself, but I guess you'd have me understand it doesn't matter for our purpose, right?
No, I believe that specifies Augustine was the landlord.
All right. Well, you know what, Sugar? It doesn't have an issuance date. This is just a portion of an order. That's the problem. I don't even know when it was issued.
Hold on a second. Page 1, page 2, and page 3. There's all 3
Thank you
pages.
very much. You covered the
One
screen
you
one?
don't need. I gave her.
Okay.
She has. Okay, that first page is part of the FOI.
Oh, you double-sided everything, is that it?
Yeah.
All right, bear with me.
No choice. We got a lot of paper.
No, I understand. I'm just trying to coordinate this. Okay, so you give me 2 of this. I'll give you one of these back.
Okay.
And here we go. We're good. We're in business. All right. So this is the same order, SOL 19372-11, issued October 18, 2011. Okay. So
There is more, actually, sir. On February 1st of 2017, during a conversation with John and Augustino, Marie, and myself, John insisted that Augustino was, in fact, a landlord for 99 East Avenue South.
well, can we just stop park for a second? What we have is a board order, which is a determination of the status. Your private conversations, can we focus on this for a moment? Because you actually have a ruling by the board identifying someone, rather than your he said, she said discussion. I'll get into that if you'd like, but I think you'd have me understand that this should be kind of a primary assessment tool for me. Is that right?
One of them, yes. But I think it's enough by itself. We'll go with that.
Well, I mean, if there's more, you can tell me, but I'm actually keen to get to this. So go ahead with the rest of it, though. So you had a discussion,
Very
right?
briefly, then, I recorded that conversation.
What conversation?
The
Start with.
conversation with myself, Marie, John, and Augustino. And in it, Mr. Sereno quite clearly states that Augustino is a landlord at 99 East Avenue South. In fact, he's quite aggressive about it.
When did this discussion take place?
On February 2nd, on February 1st of 2017.
Okay. Where Augustino asserted that he's a landlord?
No, John did.
John asserted that
Augustino agreed with it.
that he's the only landlord or a landlord?
A landlord.
Okay,
That Augustino is a landlord at 99 East Avenue
Bear with
South.
me. Bear with me. So John and Augustino made this assertion in that discussion?
Correct.
Okay, gotcha. All right. And you see how that recorded somewhere?
Yes,
Are you intending to play that or something?
I can.
Well, hang on. Do you have that reduced to some kind of portable format for Ms. Greenway and myself?
Ms. Greenway has a copy of the disclosure. This is all digital files, sir.
Could you answer my question, though?
Yeah, she...
You're not answering my question. Okay, there may be digital files there, but my question is, my specific question was, is this conversation recorded somewhere in a portable format? That's all I'm asking you.
Yes, it's a digital file.
Okay, well, you didn't actually answer my question. You just said, here's a stick with digital files. I just needed you to answer my question. Because, you understand that?
I'm not sure I understand.
Oh, that's fine.
Say yes.
What I'm saying to you is, and I'm setting the stage for a continued engagement. All right? Because I don't want you to think I'm rushing you through this. I think we're having a communication challenge, you and I. I asked you, is this reduced to a portable format? You started hold up a disc, and you said files are on this, that, the other thing. You didn't answer my question directly. My question was this reduced to a portable format? I think you were answering the question, but you actually weren't.
Yes.
I know that's a USB stick. It may very well contain electronic files. That's possible, but you're not answering my question.
Yes.
I'm just doing this so you understand what it is I'm asking you. So go forward. I don't need you to answer immediately. I don't give brownie points for immediate answers. Just need you to think through the question and be responsive to the question. Is that a fair assessment? Is that a fair request of you then?
Yes.
Okay. I hope. Okay. Let me know if you think I'm crossing a line. I don't want you to offend you, but I just wanted to make sure that we're communicating capably.
Mr. Chairman, you don't offend me. I just find you very difficult to understand at times.
I understand that. So you let me know when that's the case, and I'll reframe. Reasonable?
Reasonable.
Appreciate it. So that's on the USB stick?
Yes.
Lovely.
Your question is yes, Mr. Chairman.
I really appreciate it. How long is that discussion?
A little over an hour.
Oh, okay. But I'm assuming that discussion, the hour, isn't taken up entirely by this assertion. I'm assuming that assertion is a portion of that time?
Well, the assertion is scattered throughout the conversation, but most of it is concentrated in the last 20 minutes.
Okay. What you're telling me, I think, is that you haven't been able to localize that admission to a particular series sequence of words. It's somehow built into a 20-minute discussion? Is that what's going on?
More than once.
Yeah,
in the 20
it was
minutes.
repeated.
Well, all I need is, okay. I just need, I get you. I wasn't, okay. It may have been repeated multiply, but my question was, can you localize where it was at least admitted to once?
I could, yes.
Is that a 20-minute admission, or is there a shorter admission?
I'd probably get down to 5 or 10 minutes, but...
Yeah. All right, well, hang on a second. Let's put a dog ear on that for a second. I'll circle back to this, don't worry. Question. I'm turning to you on this, the two of you. I guess my ultimate question will always be in these types of circumstances where a tenant queries the identity of the landlord. Is it possible that all you care about is that at the end of it, there's someone holding the rope for liability purposes, whatever their identity?
Yes and no.
Yeah. If
That's
we
a
don't-
big part of it. Sorry, go ahead. Mary.
If we don't have to deal with John himself, because he's the only landlord, we'd rather deal with Augustino.
Well, if they're co-landlords, I don't know what they are, but if they're co-landlords, you still have to deal with them in the hearing process. You mean going forward in your
Personally,
relationship?
going forward and
Yes.
having repairs done. Because we get the excuse from Augustino, he can't make any of the decisions. It's all up to John.
Well, this is what kind of governs my analysis, generally speaking, okay? Relationships are contractual, tenancy relationships. Is there a written tenancy agreement identifying who's who?
no.
No.
There was an oral agreement?
No.
Nope.
Well, what was it?
Sorry, there was an oral agreement at the very beginning.
Was there a written agreement?
No.
No.
All right, bear with me. Okay, bear with me a second. All right. All right. I kind of see their point, Ms. Green. I don't know if it's germane to my analysis, to be honest, but I think what they're saying is that they want to have some conclusion as to who it is they have to interact with going forward in the tenancy.
Right.
Now, I'll let you know, sir, on that. I don't know whether that in and of itself is sufficient to have me explore at length this issue, but bear with me. I think what more interests me is that we have an order setting out Augustino as a landlord, would suggest to me a board determination with respect to that fact.
I believe so as well.
To me, that's something I need an answer to. If you want to play for me this tape, I guess you can, as long as we both have copies of it. I will, but I'm in your hands. I don't want you to all feel that I'm short-circuiting your ability to advocate a position. I think what's of interest to me is this order.
It'll come up later, play it later.
Okay. No.
Well, the identity of the parties is a preliminary issue. I don't, Mr. Bosch, dispute your interest in getting conclusion of that before we get to the substance. In fact, we ought to before the substance is addressed. You need to know who you're dealing with. I don't care about the tendency for the sake of the hearing.
Yeah.
I guess my own orientation around this kind of stuff is that as it relates to the hearing process, generally I would expect, although every case is different, I would expect as long as someone's at the back end who can be saddled with any liability that I determine should accrue, that's all you should care about as it relates to the hearing process. Does that make any sense?
Yes.
I know you have a broader interest, and I'm not going to short-circuit that, but I want us to focus at least to some degree on why we're here in this process. Does that make any sense to you? But I'm not going to, I don't want to give you cause to think I'm trying to undermine your preferences here. But do you want us to make this exploration then?
Well, it's going to come up as well. I mean, if Augustino is a landlord, then we intend to ask for an amendment to all the applications to include him as a landlord.
Okay. Can I just say something? I hear you. Bear with me for a second, okay? We'll continue this engagement. I want to read to you the definition of a landlord in the act so you can understand the framework that we're talking about.
All right.
A landlord includes the owner of a rental unit or any other person who permits occupancy of a rental unit other than the tenant who occupies a rental unit in a residential complex and who permits another person to also occupy the unit or any part of the unit. And it goes on. Okay, but you know what I generally observe is that sometimes the titular owner styles themselves as a landlord. Sometimes a property management company styles itself as a landlord. Right? There is no statutory precondition as to what specific entity must be styled as a landlord. The definition is it actually goes the reverse. It says this is the range of people who can be landlords with these very limited exceptions.
Yes, I
So
understand.
you understand that, right?
Yes.
So the exploration never turns on, well, what does the law say? Well, not never. It rarely turns on, is there a specific individual who has to meet that definition? No, no, no. A variety of people can meet it. The question ultimately for me is, what does the contract set out with respect to that? And what have previous board rulings that are still live, what do they determine on the matter? Those are the only real considerations that matter. Does that make any sense?
It does.
Because we're not dealing with interaction on the street. We're dealing with contracts. Does that make any sense to anybody?
Yes.
All right. I'm more than glad to make this exploration if you think it is meaningful. I just want you to know, as it relates to this application, what's meaningful from your end should be, at the end of the day, if liability accrues, that there's somebody at the back end who will be subject to it.
Well, Mr. Chairman, we'd like the liability to accrue to the person actually responsible for it. Okay.
Listen, you're not hearing me say I'm not going to explore it. I was just giving you a framework of orientation. Do you understand that?
Okay.
I'm not resisting anything here. But I just wanted to, here's my goal. You might be offended by it, but let me know. My goal is, and this is what I do, this is my job. I'm the conductor of a train. Okay? And my job is to efficiently engage process so we deal with what matters. Now, I'm not suggesting for a moment that the identity of the landlord doesn't matter. Don't get that twisted. But we do have someone holding themselves out as the landlord who will be subject to any order that I make against them. But if we need to make this exploration, I'm prepared to make it. Shall we make it then?
Yes, please.
Absolutely. I'm more interested in this order, though. We got to turn back to this order. That captures my attention. Anyway, so you're going to play a recording?
I don't think it's necessary at this time. I think
We can go to the order.
I think the order itself. should be
Well,
sufficient.
I mean, well, let's explore that, and that doesn't give us grounding. I'll give you a chance to.
Fair enough.
Fair? All right. Well, Ms. Greenway, the ball's in your court. We have an order identifying Agostino Sereno as the landlord. Is it not this unit? Well, there's not a unit. Okay,
There's
no.
another unit.
Hang on a second. This order doesn't set out a unit. It just says a municipal address absent a unit.
That's correct. However, in that particular building, there are only 2 inhabitable units, and Mr. Pollington moved into that unit in mid-2011.
Okay.
So there's only one other possible unit. As well, that order refers to the windows on the second floor of the rental unit. I believe he meant the second floor of the building, because there is no second floor in any of the rental units in that building. That would pin it down. But the easy way is to ask.
No, hang on a second. That's not the easy way. I have to understand what this order tells me. Maybe that's your easy way, but I have to be mindful of board jurisprudence that binds me to certain things. Do you agree with that? Well, whether you agree with that, that's how it works. I am worried, though, that this order doesn't actually identify the unit.
Okay.
That's my
And
worry.
I did try to identify the unit and ask for the hearing recordings. That would have made it very simple. However, they're not available to me. They're only available to the landlord.
Well, yeah. Oh, and the tenant, there's no tenant name identified here. What's going on here?
Well, they redacted that.
Right, but August, okay, hang on a second.
The
Hang
unit
on.
number?
Hang on a second. Is this in relation to your tenancy?
No.
It's in relation to our unit, sir.
Be at peace. I don't know. because there's everything's redacted here. Does that make sense?
Yeah.
You collected this. I wasn't present with you when you did it, so I don't know what this is about. Just hold on a second. The order is for the unit, tenant says, but not for the tenancy. Gotcha. Okay. Well, you know what? Bear with me. Bear with me a second. All right. Okay, so I can't rely on this order. I thought you presented it to me because it was in relation to this tenancy. But it isn't. So it can't govern my assessment as to who the landlord is under this tenancy, because that could change from tenancy to tenancy. Does that make any sense?
Okay.
Does that make sense, ma'am?
Yes.
All right, bear with me. All right. All right. Well, that tells me then I'm more than ready to consider your what evidence you have concerning who the actual landlord is.
Okay.
All right.
Just a moment. May take me a few moments
Take your
to
time.
find the exact spot.
Take your time.
Sorry?
Take your time. And as you're finding it, I want to continue to engage briefly just on this. So, Ms. Greenway, look, this Agostino fellow, right?
Yes.
He's not prepared to kind of accept status as a landlord for the purpose of the proceeding?
No.
All right.
So it's in my best interest to keep a tenant that's in that zone. Wouldn't you assume that it's going to, if there's an issue that's not
Backward, you call the plumber or whatever, and there's an issue so far, and read.
I was put in the hallway too.
Till later, the bill started getting high, and says,
I'm just telling you, there's something I'm going to be doing, or it's...
yeah, who our landlords are, is our
Thank you.
user.
Because he's the one that uses the first floor when he comes in and out the door, and that's the way we work. If he doesn't want to...
Using the original wiring, all the first floor wiring, even the hallway.
Can you pause that for 1 second?
Sure.
And since Agostino's interest will be affected, I probably need to have him in here.
Yeah.
Can you let him speak? Or somebody? Thanks.
Is it okay if I just keep looking here, Mr.
Can you do it more quietly?
Turn the volume
We had the same issue on the other side.
Hello, sir. Could you state your name?
Agostino Sereno.
All right.
Good
I'm just
afternoon.
telling you,
All right.
there's something I'm going to be
Okay, pull up a chair, Mr. Sereno. I've invited you in here because an issue has arisen with respect to the identity of the landlord, who the landlord is for this unit. And this pertains to 99 East Avenue, Hamilton Units 2. The tenants assert that you are, in the very least, a co-landlord, okay? I understand from the screenway that you're simply a witness to this proceeding and not a landlord, but I have to figure that out. But since your interest will now be affected, you are now an interested party, I decided to bring you in so you can participate with respect to my engagement concerning your prospective status as a co-landlord. Does that make any sense?
Co-landlord.
That's what the tenants are saying. I'm exploring that issue. You understand that?
I helped John.
Stop.
But I don't.
Stop.
Okay.
I'm just letting you know where we are in the process.
Okay.
You just need to keep quiet for a minute. We're all going to expose to the tenants alleged evidence pertaining to your status. I want you to listen to it, and I'll give you a chance to respond to it. Fair?
Not a problem.
Meter, and it wasn't taken off at any point.
No, but that's the way it was.
But at one time, was it an issue? Till later, the bill started getting high, and he said, I'll let you go.
I've got a problem with it.
Right?
All right. Thank you again.
But you'll have to come into the basement and check the meter.
Is that it, or are you still searching?
Okay, that's fine.
I'm sorry?
Are you sorry? I'm sorry. If you're still searching, that's totally fine. I just don't know if you're actually playing what you
still
intend.
searching.
Fine. Here's what you're going to do. I'll have the commissioner come in here. You let him know when you found it, and I'll be glad to resume at that time. Is that fair?
Sure.
Thank you so much.
No problem.
I will now recess.
One thing I want to do
The record. Okay, Mr. Barsh, the commissioner tells me that you called me back in. You ready to go with it?
Yeah, this is towards the end of the conversation, and it's a summary of what was discussed earlier.
Okay. So this is okay. So when did this take place?
This took place on February the 1st, 2017, in our unit at number 299 East Avenue.
February 1st, 2017. In unit. Discussion between who and who?
Myself, Marie Ball, John Serino, and Augustino Serino.
Okay, bear with me. All right, thank you.
Okay. And this takes place at 1 hour and 39 seconds into the recording.
Oh, thank you so much.
And the file name of the recording is 2017-2-01-conversation-Peter Augustino.
Well, you know I can't write that fast, right?
Sorry.
All right, bear with me. Thank you. Oh, thank you, sir. Dash conversation dash what?
Peter, comma, Augustino, comma, Marie, comma,
Okay, one second. Yes?
John, dash, voice, 009.
00. Thank you, sir. All right.
That's the file name, and actually, I guess I'll give you these two. This is the copy of all of the...
Okay, just give me the one that pertains to this one first, if you could.
I'm not sure which one.
Fair enough. I'll take them both. And the screener has a copy, correct?
Yes, she
Appreciate it.
was provided disclosure on the 21st, I believe it was.
Lovely. All right. This is what, 20 minutes? How long is this?
This part of it is only a couple of minutes.
Lovely. All right. Let me know who's talking too when they start talking, because I won't know, right?
Okay.
If you can recognize that. Okay.
Let you know we're coming was Augustino's voice.
Okay.
Just to be clear,
That's me.
Okay.
Augustino, you do have an interest in this building, is that correct? I do have an interest in the building, thank you.
That's
So you are in fact one of the landlords here? I am partial landlord.
Hold on.
Okay.
I do have
An interest in the
an
building.
interest in the building. I am a co-landlord here. Is that what you said?
You said partial then.
Partial landlord. Okay. Here.
Yes.
All right. Anything else on the clip pertaining to this?
Okay, well, that was news to us, actually. I know.
Okay. All right. Any other admission around this? That's all I care about.
We just went to that.
Oh, well, I guess, is that everything on that?
On this point, yes.
Okay.
Lots more in this recording.
I get you. Anything else you want to present to me around the identity?
No.
Okay. Screen any cross?
Yeah. Can I ask him actually directly?
Ask who?
I'm going to ask.
Well, here's where we're going to go. There are three. This is now the complexion has kind of changed a little bit.
Okay.
We have three parties functionally. At least you are an interested party so far. My intention is to engage him at distance from you because you're not here representing him, are you?
He's a witness.
Are you representing him too?
Yes.
Oh. Okay. Do you have any questions for the tenants then?
Yes. When he said he had an interest in the building, did he say he was owner of the building?
Sorry, just one second. What I heard was I'm a partial landlord here. Is that what I heard?
Yes?
Okay.
Okay. He is someone who works for the landlord. He does take care of all the paperwork.
Is there a question coming out of this?
Yes, but he is.
It's not a question, Ms. Greenway. Come
Yeah,
on.
I know. I can't. Who showed you the unit?
Mr. Collington and his son, who was a former tenant at the building.
Before you moved in?
Correct.
And who at that time did they say was the landlord?
John. And he did mention that he had a brother who also worked in the building. He didn't
Okay.
specify his status, as I
So
recall.
a
That was
landlord
few years
is
ago.
the owner of a rental unit or any other person who permits occupancy of the rental unit, other than a tenant who occupies a rental unit in a residential complex and who permits another person to also occupy the unit or any other part of the unit.
Is there a question coming out of this?
No, I'm just making that out there. That
Well, this is the time for you to ask questions, Ms. Greenway. Any other questions?
So at that time, he did actually tell you that John Serino was the landlord.
He said that John was the landlord, but he did not specify that John was the only landlord. John was the one who actually told us that Agostino was a landlord later on.
But at the time that you took the rental, it was John Serino that was the landlord.
Yes, as far as we knew.
Okay, hang on. Who told you that somebody allowed you entry?
I'm sorry?
Somebody allowed you entry? What happened there? At the time you took possession of the unit, somebody let you in? You
Oh,
can't,
that
it's
was
always too
Agostino,
fast.
actually.
To show
Sorry?
the
I
unit.
think it was Agostino. To see the unit or to move in?
You just started, you said something. It's hard for me to know what's really
To
going
show
on
the
here.
unit.
One second. You responded to the question that somebody showed you the unit.
Mm-hmm.
Who was that?
That was Mr. Paulington and his...
Yeah, I didn't know who that was, so that's why I got confused. That's somebody.
Yes.
Well, I don't know who that is in relation to this matter. Is he a co-tenant? Is he a fellow tenant, or is he somebody else? Does anybody know?
Well, that was our next question, exactly what his status is.
Are you suggesting this person's a co-landlord too? Is that what we're going to be
No.
saying? I'm not worried about him then. Let's not worry about him in terms of his status if you're not asserting he's a co-landlord, okay?
Okay.
But this person, somebody, showed you the unit.
Yes.
Right? Who is this person in relation to anything? Do you know?
Well, at various times he's been referred to as the caretaker, the
All
superintendent.
right. Is that a proper
and
characterization of this guy?
Yes.
Okay. So super showed tenants the unit. When was this now, roughly?
That would have been September 17th, I believe, 2015.
Thank you so much. And he told you, the two of you, what?
I need to correct. He told him
Okay.
I was out of town.
Sorry. Thank you, ma'am. What did he tell you?
He's basically told us, actually I don't even think he mentioned John's name at the time he was showing me the unit, but he told us to come by and he'd let us know whether or not we got the unit.
But you said something earlier, though, in relation to Mr. John being the sole. I thought that you said sole landlord. Is that not
No,
what you
he
said?
never told me John was a sole landlord.
Okay. Did he tell you anything about who was the landlord?
At the time of showing the unit, no. I think it was later that he actually mentioned that John was a
Oh,
landlord.
but okay. At some point he mentioned, whether it be that moment or sometime thereafter.
Yes.
Okay. All right. Okay. Any other questions?
No.
Agostino has, there is a bit more, Mr. Chairman,
On what?
on the subject of Agostino being a landlord.
I thought you concluded. That's why I allowed cross-examination. Now you want to invoke more? When I ask you how to add everything, I take you at your word, and then I proceed with the process. Listen, I need you all to understand something. This is not a free-for-all. I ask specific questions. Have you finished? And then when you tell me yes, I accept that. And then I move forward to another part of the process. I don't generally allow people to reinsert or re-invoke those elements that I've already concluded. If you haven't finished, you got to tell me I haven't finished. I'll allow you to finish. But you can't assert yourself later on to say I have more. This is a legal proceeding. That's how, and I told you way at the beginning, the order of proceedings. And I'm just trying to follow that. Does that make sense? All right. Are you okay with that? All right. I can't hear you.
Yes.
All right. All right. So now it's time for me to ask. Well, do you have any questions of Mr. You see, okay, Ms. Greenway has indicated that she's acting on behalf of what's Agostino as well. Okay. So I'll engage that shortly. Let me see if I have any questions of you. So there was no written tenancy agreement, correct?
Correct.
Okay. When did the tenancy start?
October 1st, 2015.
Bear with me.
We took possession, I believe it was September 29th.
Okay.
2015.
Okay. Thank you. All right. All right. And no written, no. Who did you understand your letter to be at the time?
John Serino and possibly Agostino, but
Well, no, there's no possibly. It's like, are you pregnant or not? After 9 months, you'll know. My question was to you, because you're not answering it, and I don't like that. Who, at the time you entered the tenancy agreement, or who did you understand your
that would
landlord
be
to be?
John.
Okay, that's all I needed to know.
Okay.
There can't be shades around that. Like, who's your wife? Well, it's Jane, possibly Pauline as well. That's not how this works. Does that make sense?
It does.
All right. I'm just trying to let you know that it's not giving me the clarity that I need. All right. Okay. So, do I infer that it is Mr. I'll use the first name just to distinguish. It was Agostino's statement to you, an admission on in the recording that you played. Is that what prompted you to consider that he was a co-landlord as well?
Yes.
Okay.
And he told us that multiple times, and so did John. Not all of them were recorded.
Okay. Gotcha. All right. Okay. Anything else you want to tell me in response to the few questions that were put to you?
I'm not sure.
So, fair enough. So the process contemplates that you tell me what you're going to tell me, then you conclude that. The landlord's given a chance to cross-examine you. And then, and I'm given a chance to ask clarification questions. But there may be something you want to tell me that would have arisen only from the questions put to you. So you couldn't have anticipated those questions. So you couldn't have told me those things during your evidence in chief. So I'm obligated to give you a narrow opportunity to speak to things that arose in the course of those questions, but nothing more. Does that make any sense?
Okay.
Anything on that basis?
No?
Okay.
No more questions?
All right, fair enough. Ms. Greenway, in response?
No.
You don't have a response to this?
His brother is the... John Serino is the landlord with Agostino Serino as his brother, and he works for him, sometimes maybe acting as the landlord if John's not available.
Is that everything?
Yes.
Any questions of any of them with respect to this?
No.
Okay, I'll have some. Agostino, you don't mind if I use your first name, do you? Just to distinguish you from your brother? I just heard a recording of a discussion allegedly involving you that occurred on February the 1st, 2017, wherein you, I'll read this. I do have an interest in the building. I am a partial landlord here. Was that you? Is that your voice?
Yes.
Why do you say it?
Because he's my brother and I act as a landlord when he's not available.
Who's he?
John Serino.
But you said that you're a co-landlord. That's different what you're telling me now. You're saying you step in the landlord's shoes when he's not available. Hang on.
Correct.
I just don't understand the connection there. Because I think what you're trying to tell me is that when he's not around, you functionally step in his shoes to undertake the activities that he otherwise would.
Yes.
But you said in your recording that you are a co-landlord, which is a different...
Partial landlord.
Thank you. Thank you for
That's what I
that.
meant.
Partial landlord.
That's what I meant by it, sir.
All right. Any redirect, Ms. Goodway? Actually, I have one question, actually. No written tenancy agreement?
No written tenancy agreement.
All right. Any redirect?
What are your duties?
Mostly repairs, maintenance, and handling issues when they come up. Issues that I have to address with John before I can continue, because he has the final say in it.
Okay.
Is that everything?
Yes.
All right. All right.
Do I get to cross on that?
You already... well, here's what happened. I gave you a chance to cross at large, and I said, hey, you're going to cross-examine all three if you want. I did say that.
On that one
No,
question?
no, you don't. You were given a chance... Let me tell you. Let me reframe that. You were given a chance to ask questions of all three. I said, do you have any questions for all three? Only Ms. Greenway spoke, but I said, you can ask questions of all three. And you remember that at all? No, I'm asking if you remember it. So I don't want you to feel that you're being prejudiced in this engagement. Do you recall that?
Yes, yes, I do, Mr. Chairman.
Okay. I just want to be careful because I don't want you to feel aggrieved. I want you to air your concerns before me. That was your opportunity to cross-examine.
Okay.
Then I asked clarifying questions, as I told you earlier. Does that make any sense?
Okay, but the questions I have were inspired by Ms. Greenway's question to Augustino, and you also said if something comes up because of the questions, to ask it.
That's not how it works. You misapprehend. I'll clarify for you.
Okay.
The opportunity to re-examine would be Ms. Greenway's of her clients. The opportunity for you to re-examine, to be responsive to questions arising from cross-examination are yours as it relates to your examination in chief. So you understand that. So you give testimony, they get to cross. I get to ask clarifying questions. Then you get to re-examine on the narrow issues arising in those questions. But you examine on your evidence. This is not your evidence, this is the landlord's evidence. You don't get to re-examine that. That opportunity lies with Ms. Greenway in relation to her client's evidence, in the same way that your opportunity lies with you in relation to your evidence. Does that make any sense?
Yes.
Ma'am, does that make sense to you?
Yes.
Alrighty. Alright, to my ruling. Here's the problem. No written tenancy agreement. Now, that's not your fault. I don't look to tenants to codify these things. That opportunity generally lies with the landlord. The pen tends to be in their hand, right? There's nothing here. Now, here's the situation. We have a gentleman who admits on tape to having identified himself to you at a point in time as being a co-landlord. Mm-hmm. He's provided some information, evidence here today, or at least attempting to clarify what he meant by that. When I say partial landlord, that's his term. That he meant to communicate in that he stands in the landlord's shoes in his absence as an assist, as opposed to a co-landlord. Now, who really knows what's really going on here? I don't know. But I think the landlord has satisfied me that Augustino is not a co-landlord. Okay? Sorry?
Well, Mr. Chairman.
Yes.
That's not consistent with some other information, but...
What other information?
All right.
What are you talking about?
The bills for the gas for 9090 and 97.
But why didn't you adduce those in the presentation of your evidence in chief on this?
Because I don't know what I'm doing, Mr. Chairman. Okay?
Well, I appreciate that admission, but here's my problem, okay? And you're not slowing down the process. I'm not alluding to that. But I kind of hold people to an expected framework because I can't do anything else. Otherwise, this becomes a free-for-all engagement. Now, the duty counsel engaged you for 20 minutes or so, or half an hour at the beginning of this process. I would have hoped that orientation would have enabled you to at least orient around process. I'm not going to allow you to reassert or re-invoke the presentation in chief on this issue because I asked you, had you finished? And you said yes. One doesn't need to be a lawyer to apprehend what that means. Have you finished? Is there anything more? No, there's nothing more. That's not a legal thing. That's just a common parlance. I'm not going to allow it. We have to move forward on this. If you have any submission you want to make around bias or otherwise, I'm more than glad to hear it.
Well, no, it doesn't appear to me to be biased, but this seems to me to force me to go into great and painful detail on every little point.
Listen to me. What you're seeing from me is I'm prepared to entertain anything that might be germane to my jurisdiction. You express some concern, and I respect the concern. I just don't feel that I've been treated appropriately in this. I get you. I may not agree with it, but I get you. And through the course of today's proceeding, because you were good enough to raise that, I'm trying to take extra pains to make sure that I give full shrift to everything you present. Okay? But you have to do it within a framework.
Okay.
Does that make any sense?
It does.
Otherwise, we'll never get through this. At the end, and I'll say it again so we move forward. When I say, have you finished everything? When you tell me yes, I take you at your word. All right. To my ruling. Okay, so I made my ruling with respect to this issue. Look, circumstances may change in the tenancy going forward that may give rise to a belief that the landlord identity has changed. You may in fact file an application pertaining to that because circumstances change. Do you understand that? This issue isn't resolved going forever. It's resolved until new information surfaces that causes the board to reverse this or to have a different conclusion. Does that make any sense?
Okay.
It's only
This question is still open, is what you're saying?
not for today, but I'm saying things may change in the future.
Okay.
There's nothing stopping you from filing an application directed at assessing those elements. Does that make sense?
Okay.
It's not a dead issue. It's just resolved for today's process. Okay. All right. What's your next preliminary issue?
Who represents whom? Whom does Ms. Greenway represent and in what capacity?
Ms. Greenway?
I'm a licensed paralegal for John Serino and Agostino Serino.
Do you represent Richard Paulington?
Yes, I do.
Who?
Richard Paulington.
Who is that?
And he's a party to one of the applications. He's the superintendent.
Okay. All right. Well, okay. All right. I don't have to worry about him now, though, as a party, because he's not, correct?
To the T6?
To the current one, SOT 77620. He's not here anywhere on this. Is that right? Do you want to raise that for when we get to the case involving him as a named party, or would that be more efficient for your purposes?
Do we want to wait till we get to the case?
This fellow isn't even before me as a party. So asking if she represents him does not move the ball forward in the hearing of this application. But if his identity is at issue in an application where he's named, maybe you want to hold on to that concern and raise it there. Is that? I'm in your hands, though. Whatever you'd like.
No, that's fine.
Okay. So are you withdrawing that preliminary issue, whatever it was?
Yeah.
All right. So I won't even make any notes on it. Fair?
For now. Yeah, fair enough.
Okay. And you can reserve it to what it becomes relevant. What's your next issue?
Okay, the interim order
Yes.
that you issued in the last hearing,
Yes, sir.
I believe was dated October 1st of 2018.
Yes, sir.
Okay. I tried to have that enforced through the Rental Housing Enforcement Unit,
Alrighty.
and they told me it was unenforceable.
Which one was this? Which provision are you referring to?
Just a moment. Let me pull that up.
Sure.
Interim order. They actually told me none of the provisions were enforceable because there is no section of the Act on the order specifying your authority to order this. That's what they told me. And they're correct, there is no section of the Act on here.
Okay, bear with me a second. Bear with me.
So I was at...
Just bear with me, okay?
Sure.
All right. All right. Gotcha. Alrighty. I hear you. I get you. So you're asking that I amend the application to include those provisions?
The application?
Oh, sorry, my apologies. I meant you're quite right. I meant the order to include those provisions? Is that what you're asking?
Yes, with a few more, please.
Say again.
Yes, and we'd like some added to it.
Added to the interim order?
Yes.
I don't even know what you're talking about. Bear with me a second. I'll make some notes. Right. Are you content with that, Ms. Greenway? I mean, the order, what happens is the template drives the drafting of these things. I should have been more thoughtful. But the interim order template really doesn't have the statutory provisions governing each issue type. It's only the final order that does. Typically, there's never been a problem. But if they enforce, you say an enforcement unit? Is that you said the enforcement unit?
Yes,
Okay.
the rental housing enforcement
All right.
unit. I spoke to an
Okay.
officer.
All right. I hear you. I get you. Okay. Do you have any concerns with respect to me amending the order to set out the statutory provisions related to each issue?
Which order is this?
The October 1st, 2018 order. As you know, in the final disposition order generally, I'll include the statutory provisions governing my jurisdiction for each issue. The interim order generally refers to the provision of the SPPA governing my authority to issue an interim order without the template referencing the relevant statutory, the RTA parameters or provisions. It's just how the system generates the order, but I'll be glad to, unless you have any strong objection,
No, I don't.
I'll be glad to amend for that purpose. That's fine. Anything else?
Okay, on the subject of that order, there's a couple of things that were done. The caulking was done in the gaps in the window and the window in the bathroom.
So hang on a second here. Just so I understand, bear with me for a second. So you're now trying to, just so I understand, because you know where you're going, I have no clue until I figure it out. You're about to now set out for me what aspects of that order were complied with and were not. Is that correct?
Yeah, there's no need to reissue those. They've already been complied with. You're following?
Okay. Oh, you're going to suggest how I might draft the amendment? What do you mean reissue?
Or rewrite to, I'm not sure what the term is.
The parts that were done, he's saying you shouldn't necessarily have to rewrite. It's the stuff that wasn't done.
Why don't you do this? Leave it to me just to frame this out in the normal course, okay? I'll draft it. I know what I'm doing here.
Okay.
You don't have to suggest to me what I need include or don't. All I will intend to do is to reissue the order as written and include the statutory provisions governing my jurisdiction. That's all I'm going to do. Okay? Make sense?
Okay. Well, we're...
No, what are you asking me? Something else?
Can we have a recess for 10 minutes, please?
What's going on? You can have it. What's happening?
I need to go to the washroom.
There's no problem with that. 10-minute recess? And when you come back, I want you to reframe what you're asking me because I'm a little confused. Is that reasonable? Because I may have been missing something. Because by the look on your face, I think I've missed something. So I'll be glad to hear you again on it. All right, we'll recess. Back on record. Now, the recording, I think, stopped at some unknown point in the proceeding. This is 99 East Avenue, Hamilton, Unit 2. The parties are in attendance. Time is, 4:30. Now, yes, so where we left it off, I'm adjourning to the next available date. You needed a recess to determine if there are any more preliminary matters. Anything else? Okay. All right. During the next available date. Now, here's my thinking. This will take as long as it takes. I think you've made me aware of that. And I appreciate your commentary earlier. I'm still going to control the process, but I think this is something that demands a certain touch. I think that's what you've been trying to tell me, right? Okay. So, this was assigned for... Is this thing working? You know, there it is, thank goodness. This was assigned 3 hours today. I can't suggest that I'll be able to carve out that kind of time. Okay? Normally these dockets have maybe 30, 40 files in them. This series of files have been the only one. So, here's my thinking. I think we're going to have to take this in what we talked about earlier, bite-sized chunks.
I'm sorry?
We're going to take this in bite-sized chunks. Right? I think you all need to consider girding yourself for the likelihood of several multiple attendances. I just don't see another way of addressing this and giving it full shrift. Does anybody have any concerns there?
That's how it has to be.
Yeah, I think so.
Well, as long as we can get this as quickly as possible.
I don't know what that means. I'm not trying to slow it down.
I know.
Okay, this will be. Here's my goal. I'm going to balance efficiency with giving everyone a chance to fully participate.
Thank you.
Okay, I can't attest how that would be. The thing is, the tenancy is over. So there's no, is it not? You're still there.
No, we're still there.
There with
No intention of leaving.
My apologies. I'm so sorry.
Tendency is not over.
I hear you.
Calm down.
All right. My
When you
apologies.
tell me 3 times, you're attracting my ire. There's no need for that. You don't need to talk down to me for me to understand you, okay?
Fair enough.
Okay. Well, actually, what that will do, I'm so sorry why I wasn't even aware of that. Maybe I was and totally forgot. That will give me some onus to see how if I can carve out a little more time. Because that tells me we need to begin to bring this down with some greater expedition, right? Okay. But still, you know what? There's no way that the next day we're going to finish all these matters. If we can get through one, I would be surprised. And that's fine because we have a lot of stuff, we have a lot of terrain we have to get through. But my thinking is, and I can't forecast with any precision, but in the very least I would hope on the return to get through the tenant's evidence in chief on the T6 and allow for cross. That's given the pace that we're taking, this is my suspicion as to the likelihood of how far we'll get. Does that make sense, Ms. Greenway?
Yes.
You've been doing this work for years. Yes. Is that your suspicion as to if I give it about an hour and a little bit? Okay. Anything else? Now, we've already done disclosure, I think. We've already ordered disclosure, so we're fixed on that. Okay. Anything else process-wise or administrative-wise before I let you all go?
No.
No, Ms. Green? No. Sir, ma'am? I'll give you a chance to think about that.
I'm not
Mr.
sure how
Birch?
to frame this.
Just give it to me as you have it.
Okay. You're assuming that our evidence in chief for the T6 will be somewhat brief.
No, you know what? So let me say this more particularly.
Okay.
I was speaking entirely speculatively and in the best case.
Okay.
Generally, I can't say generally because each case has its own dynamics. But as a general premise, a T6 application starts out by being awarded an hour for its entirety. So you're coming from a perspective that has nothing to do with my general process. I'm coming from a process-based approach. So I'm saying if I give this an hour and a half on the return, I was thinking maybe we could try to get through your chief. I don't know if we can, but I want you to know I'm coming from a process where these applications generally get through in an hour.
Okay.
I don't expect for you to take an extensively long period of time, but I will start off, I'll try to give it an hour and a half, and we'll see where we go on the return, on the continued return. Am I missing something?
Yeah.
What is that?
We plan to present our case chronologically, all of it together. It won't be an hour and a half.
Well, okay, you're not listening to me. Or maybe I'm not communicating well. You didn't hear me say that I'm going to stop you from presenting your case after an hour and a half. Was that what you understood?
That was what I was afraid of, yes.
Look,
Okay.
that's not what I said.
Okay.
Let me tell it to you differently. I'm going to try to figure out how much time to give us on the next date. Okay? It won't be as much time as this application may require to be concluded. Certainly not all of them. Given the pace that we're adopting, I'm forecasting we'll need more time than we'll have available on the next date. If for some reason you thought that I said I'm going to stop you from continuing to present your case after whatever, an hour and a half, you totally misunderstood. But I have to leave at some point. So just like we've assigned 3 hours for today, I'm going to assign a period of time that will likely be less than that on the return. But it doesn't mean your case stops. It means we might have to stop for that day. Does that distinction resonate with you at all?
It does.
Okay. Anything else administratively?
No.
Sir? Okay. All right, party. Well, we've made some traction here today. I think some meaningful engagement. And I'll have a new notice sent out. I'm going to ask you within 48 hours to provide, and you're familiar with this from our prior, I think, to provide the dates which are not available for the next 4 months. Does that make any sense? I can't. 4 months.
4 months.
Does that make any sense?
Yes.
All right. I'm not suggesting it'll take 4 months for it to come back. I don't know. Given that I'm going to try to assign less time than I did for this one, it's easier for me to find less time than more. Does that make sense? Yeah. And it enhances the likelihood of me being able to bring it back sooner than later. Yes, ma'am.
I have one question.
Sure.
I have a father with ailing health.
Yes.
If something does come up
Yeah.
and there is a date, how do I...
Okay.
What
I understand.
steps...
Okay, let me tell you. So I think what you're saying is, let's suppose, God forbid, something untoward happened with your dad's health, such that you're required to be at his side or whatever.
I'm possibly facing that
I
this
am.
month.
Okay, I totally hear you. Then, what you might consider doing is contacting Miss Greenway in writing, seeking her consent to reschedule from the assigned date. But we don't want to do this until you know what date it is.
I'll give you the situation I'm sitting in now. The 15th, my dad has to have surgery, which could cause that.
Complications.
And the 19th is our next.
Of which month?
This month.
Okay, this is not coming back this month.
No, but even in that situation, what do I do if something
I'm
happens?
trying to tell you. If once the date is, I'm only speaking to this matter. I'm not talking about anything else.
Yeah, but I'm just talking in general.
Okay, I can't give you advice about anything. I'm giving you information pertaining to this file. You might want to apply it to other files, but I'm talking about this file. Make sense?
Yes.
All right. Let's suppose we send out a hearing date in the notice of hearing, and you discover, and then you've already given us the dates that you're not available for. And then we establish a date outside of those unavailable dates. But subsequent to your identifying the dates for which you're not available, some calamity happens that makes your attendance at the next date problematic. That's what you're talking about, right?
Yes.
Contact Ms. Greenway. Set out for her why that date won't work for you, and seek her consent to reschedule to another day. Then you're going to have to both write me, and I have to make the assessment. But the starting point is by seeking the consent of the other side. If she doesn't consent, you can still write me, and I'll make the decision. But that decision, the pathway to that outcome is much easier if the other side is not opposed to it. Does that make any sense?
Yes.
But either way, keep her in the loop. Right? Is that our established process, Ms. Greenway?
Yes.
All right. Does that answer your question?
Yes.
But do it all in writing so everyone is on the same page or on the documentary record. Correct?
Okay.
Any other questions?
No.
Mr. Bosch, you look concerned. What's up? You all right?
Yeah, I'm fine.
I'm glad to hear that. Okay then, so if that's everything,
Yes.
I'll wait 48 hours until we get your dates for which you're not available. Now, here's the other part too. Outside of what I just said. If you provide a range of dates that don't work, and they are so extensive we can't schedule this in a reasonable amount of time, we might simply schedule it in any event. Okay? But we're going to try to see what we can do to accommodate the dates that don't work for you, okay? All right, parties, I've kept you too long. It's now, what, almost 4:45? I'll have a new notice sent out, and we'll see you here again. Thank you so much.
Thank you very
Thank you
much.
very much.
Enjoy your evening.
You too, ma'am. Sir. This hearing block is adjourned.